Start. Criminal jurisprudence and the plethora of judicial precedents leave little room for reconsideration of the basic principles for invocation of the last seen theory as a facet of circumstantial evidence. Stop. Succinctly stated, it may be a weak kind of evidence by itself to found conviction upon the same singularly. Stop. But when it is coupled with other circumstances, such as the time when the deceased was last seen with the accused, and the recovery of the corpse being in very close proximity of time, the accused owes an explanation under section 106 of the Evidence Act with regard to the circumstances under which death may have taken place. Stop. If the accused offers no explanation, or furnishes a wrong explanation, absconds, motive is established, and there is corroborative evidence available inter alia in the form of recovery or otherwise, forming a chain of circumstances leading to the only inference for guilt of the accused, incompatible with any possible hypothesis in innocence, conviction can be based on the same. Stop. If there be any doubt or break in the link of chain of circumstances, the benefit of doubt must go to the accused. Stop. Para. It is settled that the circumstances of last seen together cannot by itself form the basis of holding accused guilty of offence. Stop. If there is any credible evidence that just before or immediately prior to the death of the victims, they were last seen along with the accused at or near about the place of occurrence, the needle of suspicion would certainly point to the accused being the culprits, and this would be one of the strong factors or circumstances inculpating them with the alleged crime purported on the victims. Stop. However, if the last seen evidence does not inspire the confidence or is not trustworthy, there can be no conviction. Stop. To constitute the last seen together factor as an incriminating circumstance, there must be close proximity between the time of seeing and recovery of dead body. Stop. Para. One more incriminating circumstance in the present case is that appellant, Dinesh was absconding for a long period and charge sheet was filed against him by PW6 Manohar Singh Yadav as absconder, and during investigation process under section 82/83 CRPC was also issued against him. Stop. This fact is an additional circumstance, which also completes the chain of circumstances, at least, in respect of appellant Dinesh. Stop. As per the judgment of Supreme Court in case of Satpal (Supra), if last seen evidence is coupled with other circumstances, such as abscondence of accused persons, then, in absence of proper explanation, on the basis of last seen evidence, conviction can be recorded. Stop. Para. The law is well settled that no benefit can be given to the accused merely on the ground of laches of investigating officers or any legality committed by him, if evidence of prosecution witnesses is reliable and does not suffer from any infirmity. Stop. Supreme Court in the case of C. Muniappan and others versus State of Tamil Nadu (2010) 9 SCC 567 held that defect in investigation by itself cannot be a ground of acquittal. Stop. Over.